Okay, so I need to just do a brief talk about this, which is in the Criminal Procedure Rules 2020, there is the word privilege appears quite a few times. The word privilege never appeared in the 2015 Criminal Procedure Rules at all. But now we've got the word privilege appearing in the 2020 Criminal Procedure Rules. And it appears in connection with or in relation to the term legally privileged items or legally privileged information and legally privileged questions. And this actually, the terms that they're using, they say to find the meaning of it, then you have to refer to some other of the Policing Acts and Communications Acts. Okay? Now, it's very interesting because in the election petition rules and in the Corrupt and Illegal Practices Prevention Acts, you've got in the book it explains that if you're in an election petition, you're usually dealing with people who are using or got privileges, and it says that they've got to answer they have to answer questions, and they can't evade answering them on the grounds of privilege, right? But I think that might mean parliamentary privilege, but it says in privilege. So this means that for an election petition, which is it's not a prosecution under the Criminal Procedure Rules, it's its own particular type of trial in connection usually with trying elections. So it's a different kind of jurisdiction. So I think that the Lord Hanningfield case and the fact that he used his privilege and he didn't have to answer the questions, and that's how he got his privilege. But I've proved that the Jeremy Johnson QC, now Casey, paper was flawed on the way that that privilege was used, because it relied on a guilty plea. Otherwise, that basis wouldn't work. And you're meant to just have a recognised, not in relationship to a defence or the defence, but it was only because of the line of questioning of Patrick Gibbs, QC, or whether or not the privilege applied. If you were covered by parliamentary privilege or any other, you wouldn't be in proceedings because you wouldn't allow it to be prosecuted. It's meant to be recognised separate from the defence or trial. Now, I think that there's a connection between that Lord Hanningfield trial, because Jeremy Johnson Casey was rewarded and raised up through the ranks to be a justice, and there's some things happened with these 2020 procedure rules since then, and the rising through the ranks of Jeremy Johnson, and they've ended up using this privilege basis in the procedure rules. And I was actually searching quite a few of the acts for the word privilege or indemnity, the word indemnity, or immunity, and the term, and also for claiming rights, and I never found it. Well, definitely it's not in the 2015, but I found it now. I've searched for the word privilege. It's all through the 2020 Criminal Procedure Rules. Now, there's a few things that are interesting about this. Through the Criminal Procedure Rules, apparently there are certain informations or items which don't have to be disclosed and can't be seized by the police. Let's look at this provision here, right? It says, under this number 54, further provisions generally, a search and seizure warrant from a court does not confer the right to seize privileged material. Okay? Privileged material is any material which a person would be entitled to refuse to produce on the grounds of professional privilege in proceedings in the High Court. A search and seizure warrant does not confer the right to seize excluded material. So there are principles in effect where the police can't seize evidence and the prosecutors can't rely on it or use it, down to privileged. And you can have privileged items and you can have privileged information, so they don't have to be disclosed. Now, I think it might be different when you're in the Supreme Court, because the Supreme Court has the jurisdiction of Parliament, unlike the High Court and the other courts. And that, in a way, is a little bit like the election petition, which is a trial or a civil proceeding to establish. It's not a criminal proceeding as such, it's to establish if anything was done wrong in an election, really. But you do have the presence of a prosecutor. It's its own unique proceedings anyway, that's for certain. But what I wanted to point out, and this is just a little example, right? Hold on a second. Well, for this part here, it says that a search and seizure warrant does not confer the right to seize privileged material. Well, can you think of any other example in any other act where the police aren't allowed to take something or seize it or touch it even, or use it? And if they can't seize it or touch it, it can't be used as evidence either, any item. Well, election material, the police are not allowed to interfere with, take or use or touch election material. So how could they use it in evidence? And that's under the Representation of the People Act, I think the 1948 one. I've got the exact section as well, just in my notes. But you take my word for it, it's in there. It's called illegal police canvassing. Now, all those materials are... The police cannot interfere with them or touch them. Now, when the police prosecute someone criminally for a criminal offence through the criminal procedure rules, they've got to be able to seize and take the information. Well, they can't do here with this. Now, if you wanted to take a legal action or trial against any election material or anything connected with it, you do the election petition rules, which is its own prosecution track, okay, and the Corrupt and Legal Practices Prevention. It's actually not through the normal criminal procedure rules. So if it's like a normal crime or a normal offence under normal criminal law, the police can't actually touch election material because it's got its own unique election petition for that, right? And that's significant because election material can, before or against a candidate or a person, it can oppose a person. So it can actually, tell people not to support or, not to vote for or not, not to get behind or whatever. Basically, just like the Stop ULEZ material, which really, there was the mayoral election coming up for the mayor of London, and they were telling people to get Khan out, vote him out. So really, that is Class E material because it's material that is connected with and meant to affect an election for or against a candidate, right? So really, and therefore it has the right to oppose. The purpose of that material is to oppose a person. It's its purpose. Can't really be prosecuted against criminally because the purpose of it is to oppose a person, right? Or even criticise them, and parliamentary elections come under parliamentary privilege anyway. And then you've got, I want to talk about Class F material, which is actually the actual petition material, like Stop ULEZ, which are the Parliament cases, and that's under parliamentary privilege. And you get to apply an enactment of law, which is the 1688 Bill of Rights, right to petition anyway. So that's not just legally privileged items or legally privileged information, it's parliamentary privileged items and parliamentary privileged information. And I don't think that parliamentary privileged items or information can be actually used as evidence in a court or given as evidence. The prosecution would have to offer no evidence. And that is really what happened with Patrick Gibbs KC, because they were saying that the questioning was going to touch on Parliament matters. and that was privileged, and therefore they didn't prosecute Hanningfield, but Hanningfield's parliamentary privilege was meant to be recognised in the first place, and Lords aren't really supposed to be judged by a jury anyway in criminal proceedings, because of Magna Carta, because of peers can only be judged by their equals. But that's a separate matter. Also, hold on a second. This is the actual meaning. The meaning of items subject to legal privilege. So this is actual items, objects subject to legal privilege, right? And this is not in the Criminal Procedure Rules 2020, but the Criminal Procedure Rules 2020 says go to this provision here in this act that we're looking at in order to get what the definition is. It says the meaning shall mean what it means in this act here, right? Now, the interesting thing about the last part of this, item number 2 here at the bottom, it says items held with the intention of furthering a criminal purpose are not items subject to a legal privilege, right? Well, the thing is, petition material and campaigns don't have a criminal purpose because they're there to persuade the public and Parliament to make or change matters in matters of church, state or law, all right? So items held with the intention of furthering a criminal purpose are not items subject to legal privilege. Well, none of the petition material or items or the election material intends for a criminal purpose, but election material, its function is to oppose persons or parties or people or candidates and persuade people not to really want to vote for them, possibly even not to like them, and even to oppose them politically, which is what Get Khan Out is doing and Stop ULEZ, really, for the Mayor of London, but also petitions to Parliament. So really, and if you think about it, election material can't be prosecuted through the criminal procedure rules and used as evidence because the police can't take it or touch it or seize it, okay? This is the basis, because they've got a completely separate and totally different trial mode and procedure rules, which are the election petition rules, right? Now, the thing is that petitions and all of their activities aren't meant to be liable to criminal prosecution anyway because of the 1688 Bill of Rights right to petition, that all prosecutions are illegal. And that's backed up by the Claim of Right 1689, that you don't have any criminal liability for petitioning, but you can be liable to civil actions. And also, the Erskine Thomas May book, Usage of Parliament, the section on public petitions, says that you do get parliamentary privilege. So all of the petitioning items, all of the signs, banners, the representations, which are advertisements to the public, they are intending to get public support and to get people to want to get the law changed or made, or even oppose certain candidates and people in government, really. That's the purpose of it. And it needs to be able to do that. So it's never criminal or harassment. Or else you won't be able to do it. You won't be able to oppose the person. And you can't say, well, it's opposing him here but not there, because the material itself, the items, have to be capable of opposing. And if they can oppose anywhere. Okay? So this whole thing about in the vicinity of Sadiq Khan's house to do with these ULEZ protesters is ridiculous. Now, another thing in these rules, these are really meant for legal. This is made for legal professionals or people engaging in law, clients, persons. But what you've got to understand when you're reading this part here, communications between legal advisors, professionals, clients, or any person, it says here, any such representative, any other person, in connection with contemplation of legal proceedings. One thing you've got to understand when you read this is that what we're dealing with when we've got a petition campaign to Parliament, which some people want to get laws made or changed, or even to the Mayor of London, to London Borough Council, but either houses of Parliament, they are doing petitions to Parliament, right? Is that it is a legal case. And at the moment, the majority of criminal law solicitors and the majority of lawyers generally and barristers and the majority of courts and magistrates, they just are refusing to, or don't like, or don't want to see or regard petitions to Parliament, either houses of Parliament, as a legal case, an actual legal case. And if they understood and knew the Tumultuous Petitioning Act, which has been repealed now, but if they understood that act and the fact that, you know, petitions did go through the courts and really it is a legal case, then a petition is a legal case and it has needs, the needs of that case, and the needs of that case are to advertise and promote it. It's different to it's like an inside out civil or criminal case, because with civil cases, you keep information secret, you don't disclose information, you keep it, there's disclosure and so forth. And even here in these rules, there is certain things that the police can't seize or the prosecution can't use, and it can't be used in evidence. The thing with the petition is that how it works is that you have to publish, disclose, share information. Everyone has to talk to each other, and you have to advertise, promote it, and communicate. So you're always communicating information with the petition to the public at large. It's how it works. It's quite the opposite from a criminal or civil case, because it's under Parliament privileges. Now the thing is that what you've got to understand is that in this piece of writing here that we're looking at, it's talking about clients, right? And information between clients or any other person who's acting in connection with this case. Now, the thing with the petition is you've got the person who starts the petition, the claimant, but then you've got all the supporters and all the people who are helping share the petition. Now, the thing is, who are the clients in a petition? Although you don't take money off them, but you have clientele, you have people that you deal with, right? This is a big point to do with this, and the Crown Prosecution Service need to understand this, and the Solicitors Regulation Authority need to understand this and really think about it and contemplate. The public at large are your clients. If you are Parliament, the whole public are Parliament's clients. Because we all go to surgery with our MP and we all do petitions. And when a claimant has a petition, he actually communicates that petition to as many people as possible and asks as many people to sign and tries to persuade as many people. And it might have to have compelling information or facts in there, or even statements, right? Possibly even evidence now on these more modern petition sites. And the thing is that really, if there's any legal issues with the petition campaign, if there are any prosecutions against it or any ones at risk of, having legal action against them when it's meant to be protected, it's in everyone's interest to talk about that and talk about the rights, get them claimed, have them recognised, and also defend and protect the other petitioners, because it's one case, the needs of other cases. So the needs of the few, the needs of the few outweigh the needs of the many. Well, actually, in a petition to Parliament, when you've got 200,000 people signed to it, the needs of the many outweigh the needs of the few. And the fact is that these people aren't meant to be prosecuted anyway. So any communication about, someone's getting prosecuted or this or that or evidence, if it is really, it's the petition campaign that's getting prosecuted. And every single person is a party to the proceedings. They're all clients of the government and they're all a party to the petition, right? Now, the ironic thing is that that information is going to be known because it's in the nature to need to make it known. You need, when you're advertising and persuading the public, effectively the jury at large, to get Khan out, whether it's for an election or a petition to stop Khan's new law or whatever, it's in the required function to do that, right? And you really need to understand that. So you can't really have, for a petition campaign to the government, you can't really have privileged items and information under the basis of them not being disclosed, not being allowed to be disclosed, because everyone needs to know them. But when you're talking about can they be used in evidence to prosecute, well, not to prosecute the petitioners, because firstly, the petitioners, according to Thomas Erskine May in the Usage of Parliament in the public petition section, they are covered by Parliament privilege. Parliament privilege is a privilege just like these legal privileges or, legal privilege, legal privileged items and information. The election material is legally privileged items and information, which the police aren't allowed to take down. And if they can't take it down, how can they use it as evidence? Because election petition material, if there's any issue with it or any illegalities, or even if it's stolen or whatsoever while there's an election on, all of the matters to do with election fraud or election crimes are not prosecuted through the Criminal Procedure Rules 2020 or by the Crown Prosecution Service as approaching a criminal offence as we know it, or as most prosecutors in the Magistrates' Court approach them or know it. Do they use the election petition? It's totally different procedure rules for that information. And in those procedure rules, what I've read, they've got to answer questions and they can't use privilege to get out of it. So it's quite different from these rules in these 2020 criminal procedure rules, which really popped up after that Hanningfield case, when you're not going to answer questions of Parliament. But this is, in the High Court as well and so forth. But it doesn't say Supreme Court, because Supreme Court is the Lords, isn't it, themselves. So, but the basis is here. And the thing is, this Stop ULEZ case that's happening now, what they're trying to do is say that the items that they were using and the information on them is causing harassment to Sadiq Khan because they're near his house. But those items have got to be, they've been using those exact items and that exact information at all their demonstrations all around London. And all over the place for the past, over 12 months, maybe a year and a half or longer, at multiple sites with police attending. Now, if that material is capable of causing harassment to Sadiq Khan, surely if there's enough people doing it, it's going to cause him trouble wherever you do it. He can't suddenly be capable of harassment and then not capable of harassment, but it's only capable if you do it in a certain area. To do it in a certain area, it needs to be capable of doing it in the first place, right? Now, the police have not seized or taken or used as evidence any of this Stop ULEZ material, mainly because it's parliamentary privileged material and items and information, but not of the type you don't disclose, on the type that is disclosed and everyone knows about, but you can't have it prosecuted against, can't be used in evidence. Like the election, a little bit like the election material, but that's Class E. Right, and you don't prosecute that through the criminal procedure rules anyway, so the police won't be seizing that. And really, this material that Nick Harler and the other people had at Tooting, it was actually get Khan out, and there was the election imminent. So, Class E material is any material relating to or connected with parliamentary elections or in London. And election material, and Class E, that material is identified because it is material which makes a representation of some kind to support for or against any candidate. That material was against Sadiq Khan, but also against him for his policies and his laws of ULEZ. And they did get some actions in Parliament. They got a motion in Parliament. So there was a motion on Stop ULEZ, and there's 3 big petitions, 200,000 signatures. One was handed into Sue Hall, the Tory candidate. Dave Fowler's, it was a proper official Parliament case with a number, and it's called Stop ULEZ. So all of the Stop ULEZ campaigns, they need to get signatures and they need to get people to support it. Their clientele is the public. The public are the clientele, right? That's an interesting word, clientele, right? Now, Parliament, if it's a petition, if the material and the information is material, which they're using for their campaign to further its objective, and that objective is a matter of church, state, or law in Class F, using the right to petition, that you can't be prosecuted for its use or imprisoned, and or criminal liability, then this is a legal case. The needs of other cases, and when these people end up getting prosecuted by the CPS, and you've got these standard normal criminal lawyers who are just in and out of the courts every day with normal criminal cases, they're very used. They don't like different peculiar types of proceedings or motions or actions or mention hearings or rights, because they don't. It's not their bread and butter. They don't do it regular or often, and it's actually quite simple getting a right recognised and mentioning it properly, because it only needs a mention hearing. It doesn't even really need a proper civil hearing. And it isn't to be regarded or misconstrued as a defence against a charge or part of a defence or defence material which is constrained by the criminal procedure rules, time limits, requirements, submission requirements, and proved to a jury or to judges. The recognition of a right in that entire act, there is no prescribed process or procedure for how you recognise a right, like the right to petition, how it has to be recognised. Only that when you claim it, it has to be recognised. Or if you know that people are using it, if you know that people are doing petitions to Parliament, you should know the right. It's just like if they've cut their finger and you can recognise that they're bleeding and they need medical attention, right? They can say it themselves, oh, I've cut my finger, or you can see that it is, The overriding, this is what, they're not teaching them this in university. They're not teaching them it at Lincoln's Inn, at Gray's Inn properly. And all of these duty solicitors and all of these, day in, day out criminal law lawyers, they're just not doing it right. If you cut your finger in the courtroom or call an ambulance, they seem to, when you get an ambulance, he's got a right. But, that's not part of a defence, or to be construed as part of a defence or proved to a court that they're injured. The only prescribed item for the right claim is actually Clause D in the overriding objectives, that it is the obligation and requirement of all parties to recognise the rights of the defendant. And that's it, right? To recognise a right, you don't prove it you have to have any evidence for that right. You don't have to have any documents. It doesn't have to be put in with a certain time limit, because in the Human Rights Act, 1998, Section 6 is about acts of public authorities, and the public authorities are like the police, the courts, and the prosecutor, but not Parliament or anything done in connection with Parliament. The petitions to Parliament are done in connection with Parliament, particularly that Dave Fowler's case is done in connection with Parliament. They are acts of public authorities. Now, In the next section, section 7, it says under 1B that a right can be relied upon in any proceedings. If a right can be relied upon in absolutely any proceedings, that means it can be relied upon in the first hearing, in a mention hearing, in a trial, in sentencing. You can even have medical rights recognised by a probation officer when you're actually serving your sentence. It means that the overriding objectives for right recognition are not to be proved in a trial. So it doesn't have to be proved in a trial. It doesn't have to be included as part of an evidence in a trial or a defence. And it's not a result of a plea. It's entirely a thing that is recognised, right, by that clause, D. And this is what there's nothing complicated about it. You know, the word mention is appropriate. You know, mention hearing or even mentioned in a hearing. It can be claimed at any time. When you have that right, in effect, it may claim before, during, or after, just like a medical right, and be relied upon. And particularly with the Human Rights Act 1998, Section 1B, Section 7, 1B, it says that you can rely upon a right in any proceedings as long as you would be a victim, right, of an act, you know, of the public authorities. So in the right to petition, it's illegal to be prosecuted. So when you have got, you know, and the needs of other, you have to recognise the needs of other cases. Well, the needs of cases to Parliament is that you have parliamentary privilege and that you've got the right to petition and that you can't be prosecuted. That's the needs of that case. And the needs of that case are to publish, print, share, display, and communicate to your clientele, to the public, matters for or against a certain cause, and it's not capable of harassment because it's items with parliamentary privilege, not just legal privilege, parliamentary privileged items. And these people are victims, so when they're getting prosecuted, they're actually victims of an illegal act by the public authorities, and they can claim those rights at any time, at any point. And it's just a simple mention. There doesn't have to be an elaborate... it's not part of a trial. You might have to sort of like spend as much time as I'm spending now to explain it if the justices don't understand it, if they're not familiar with it. But that's only because that people aren't claiming it properly. People aren't understanding it properly. People aren't using it properly. They understand the medical rights. They understand all those because it's part of training. But there's the thing with these rights is they don't like them, and they're quite important, serious rights for campaigners, for people who petition the Parliament, or people in elections, I suppose, as well. Because you won't find an action against an election in a normal criminal proceeding. In a way, it's a little bit like material for an election that supposing Sadiq Khan, you know, it's like that's why it's a good example to show the Ed Miliband and Alex Salmond advert, where they've got, you know, they're definitely belittling, if not defaming Ed Miliband. And this is a Conservative Tory advert in connection with, you know, election campaigns for the Conservatives. That kind of material, the police can't seize it or use it, or the prosecutor, because that type of material in connection with an election under Class C is meant to be tried through the election petition rules, surely. So really, that can't cause defamation either. This is what I strongly believe, you know. So there are lots of principles at play, but it does all fit perfect. All these acts are actually compatible. You know, you're not claiming incompatibility with a convention, right? There's a special procedure in the 2020 Criminal Procedure Rules where you claim that if a right, if an act or a law or prosecution is not compatible with a convention right, the thing is, all the acts is compatible because it gives you the option and the requirement to recognise political rights through the overriding objectives when you know how to do it and what they are, and when the justices understand what you're saying and what you're claiming, and the prosecution as well. And they seem to be refusing to acknowledge and apply the 1688 Bill of Rights, or even the existence of the Erskine-May book, which proves that public petitions get parliamentary privilege. And these items that they're using are the items for the petitions to Parliament are the needs of that case. It's almost like seizing items that are being used in one case for another case, but the Parliament jurisdiction is the magistrates' courts and Crown Courts definitely don't have the right to seize and have those materials or use them as evidence. Just like the election material, the police can't take it down. It's not allowed in the representation of the people. The police can't take it down, right? And it can't really cause, any harm or harassment. Why don't the police prosecute the Tory Conservative Party for those Ed Miliband, harassment against Ed Miliband when they were all over the whole country? This is the thing. So, and, maybe this bottom point here, what really the police in this case of Nick Harlett and the Stop ULEZ, these 2 in 5, what essentially the police and the prosecutor are trying to do is this bottom bit here, which is they're trying to say that the items were held with the intention of furthering a criminal purpose, which was the harassment against Sadiq Khan. But the thing is, is Sadiq Khan going to be harassed by any political party putting any material near his house saying don't vote for Khan or vote Khan out? No, because election material can't be taken or used or seized by the police. It's Class E materials, right? They can't touch it. And that's what a lot of this material was at Tooting. And you don't seize, use and present as evidence that material through the Criminal Procedure Rules 2020. It's an election petition, That's just an example. Now, there are multiple violations of the Criminal Procedure Rules by, I think, the defence solicitor and by the CPS now, because the defence solicitor is now kind of refusing to do a rights claim. He says that the defendants directed him not to, but he persuaded them. But it's not about what you want to do or what you don't want to do. It's what about the law requires and the law demands. They were using these rights, and it's a requirement for all parties to recognise them, whether they want to or not. The ironic thing is that if you have a mention hearing or a civil hearing to hear a right, it's completely separate from a defence against the charge and the trial. So it doesn't affect it. If you claim a right and it doesn't get recognised, then you just go to trial like normal. So you've got nothing to lose really by having it mentioned or trying to get it recognised. It doesn't affect the trial or the defence against the trial. Not that you're meant to be allowed to be prosecuted if it's parliamentary privilege anyway. So it's like a free try, or not. It's like an extra go or an extra try at getting it recognised. Well, in this case, it needs to be because they are using it. And this is what is stumping me about this solicitor and lawyer. In my case, I did it properly. And I have to say, my solicitor really tried to talk me out of it. She really even wanted me to plead guilty, let alone not plead not guilty. She didn't even want me to try and get this right, but I was adamant about it, and she got me this hearing, to mention the right. It was a civil hearing, and I wasn't on trial. It really should have been recognised straight away as soon as I said, I'm using the right to petition, because, it's for my investigation, straight away. We should have been in there and straight out, and that should have been the end of it. If the judge would have known that right, known about the Tumultuous Petitioning Act, known about the Claim of Right Act, known about Thomas Erskine May. And just like, I've cut my finger, I need an ambulance, she knows all that. I don't have to go into the law around it. You don't, if you cut your finger in a court, right, no one goes into explaining the law around what gives you the right to, have leave or do, or they just know. This is the thing. Now, what the courts really don't like privileges and immunities, particularly when it comes to criminal matters. And this is that's a culture matter. It's a personal issue with the justices. It's an issue with the solicitors, and it's a matter of law. But that matter of law is never a defence. It's never part of a trial, and it's never constrained by the requirements to lay evidence within a certain amount of time, within 3 days, or follow procedure ABC 1, 2, 3 exactly, or anything like that, because all of that is part of a trial and a defence, right? There is absolutely no provision in the criminal procedure rules for how a right has to be claimed, or within a certain time, or by who. It doesn't even say that the defendant has to claim it. It doesn't even say in the Criminal Procedure Rules 2020 that the solicitor must claim it or the defendant. It says all parties, every party. Now, the thing is, under HIV, also, they've got to recognise the needs of other cases. These people they're being prosecuted for a petition case that they're doing, and that case has needs. And there are people participating in that case, the needs of that petition, and all the people who are helping do it, who are helping promote it, who are signing it, and who are engaged with it. And their needs, that they're going to be affected by that trial, and their activities are going to be affected by that trial. They're a party because the Crown Prosecution Service and the police are prosecuting a case, a few people from a larger case where there are other parties involved, other clients of Parliament, right, who are also petitioning. And this is where, rights have to be recognised by all parties. I am a party to the ULEZ petitions. I am a party. That means that everyone who's doing the petition also, because of the needs of that case, has got an obligation to recognise the rights and to complain to the court. So there's nothing that it has to be the defendant or the defendant's solicitor or the prosecutor or even the judge. They're all required to recognise their rights independently of their own intellect, of their own intellectual capacity when we're evident. But there's nothing in the overriding objectives which says who can lay the right to the court and in what time limit or by what even procedure or method. None. Because the right is, we know from the Criminal Damage Act 1971 that recognising a right, privilege or interest is not to be construed as a defence against a charge. And it's the defence against the charge and the plea which have got all the constraints, restrictions and requirements under the criminal procedure rules. There is no other provision for the recognition of a right or its application or claim throughout the Act, because I've searched. It's an overriding objective. I don't think that at university, when these new solicitors go to university and learn the Act, and then when they start practicing, I don't think they really understand fully the separateness of these overriding objectives and how they are always, it literally is just like the medical right claim, because you've got a right to claim illness in community service, right? That's proceedings of sentencing, and you even get the probation officer is representing you in a rights claim, right? In your sentencing, the probation can actually recognise your probation are present in a lot of the trials, or possibly even sometimes in a first hearing, although probably rare. They're employed by the government to represent your rights, particularly mainly medical rights. This is where it's failing the system, and it comes down to a particular right which applies to political sphere of activities that is not liked by the criminal justice system. It's loathed. It's not respected. It's not liked. It's held in contempt, and it results in violations of criminal procedure rules, particularly Part 1 of the overriding objectives D and HIV, because usually you've got a case to Parliament and it's using a right. So there's those two in play there, and this privileged information, privileged items, legally privileged items, legally privileged information, legally privileged knowledge. The model for it is now, it's only just been added in 2020. It's new to this act, although there was all these legally privileged items, information in some of the other police acts, but not in the procedure rules. But you can have parliamentary privileged items, parliamentary privileged information. And the information, to oppose Sadiq Khan's ULEZ, is parliamentary privileged items or election material, which that gets prosecuted by election petition, not actually by criminal procedure rules 2020. And the prosecutor really can offer no evidence. That's what happened in the Lord Hanningfield case. And the thing is, they are doing petition campaigns to Parliament. It is under parliamentary privilege, and that's privileged items, privileged information, privileged representations, privileged knowledge, but not legally privileged, as in to be concealed, because parliamentary privileged materials are actually disclosed, shown, shared to the public, and everyone who is acting, helping that casework and engaged in it has a legal interest in it, because it's the needs of that case, is to have their rights recognised, all of them, not just 5 of them or 2 of them or 1 of them. So there really is nothing in the criminal procedure rules that says that only a prosecutor, the defendant, or a judge, or a solicitor or a barrister can recognise and claim a right on the behalf of the defendants. And it's not about whether the defendants want the right claimed, or even if they understand it or not. The needs of other cases is the needs of the people participating in another case, the needs of the petitioners of that case. Recognising and understanding under the Public Act 13, Charles I, the Tumultuous Petitioning Act 1661, what actually it is a legal case. It is a legal case in proceedings to the Parliament, and it's got, you get parliamentary privileges with it. That's the first big thing, and then the rest. It's all there. Everything is there in the procedure rules for full compatibility. There's just a stubbornness there. You can get this right recognised through the court's complaint system. You can get it recognised, Solicitors Regulation Authority are supposed to make solicitors, barristers, and some of the Crown Prosecution Service have to comply with the SRA rules. The Solicitors Regulation Authority are meant to act. The Crown Prosecutors are meant to follow the rules when you complain to them. If they're not, the court themselves, you can complain to the court, to the judges. There are so many official. What is the complaint for? I mean, it makes you wonder what these complaint forms are even for. They don't go anywhere. They just go down a bin chute or something, or you can't have any action from them, or they, but why would you have them? What would they exist for? So it's when I found this legally privileged information or legally privileged items, it's kind of helped a bit, but it's only just appeared quite new. But there's definitely a relationship, that there's a comparable relationship with the Representation of the People Act, that police aren't allowed to take down, interfere or touch election material, and if any election material is tampered with, or if there's an offence under that act, it's an election petition on corrupt and illegal practices. It's not the criminal procedurals, as far as I know. And particularly if it's petition material, it's items of parliamentary privilege. Information with parliamentary privilege. So I don't think the prosecutor can offer any evidence in this case, and even without offering any evidence, he's meant to recognise the rights and the fact that the defendants, if he does pursue the prosecution, are victims of an illegal prosecution. The defendants are victims of an unlawful act by the public authorities. And those rights can be relied upon in any proceedings. The whole campaign is a victim, because if 5 of them are prosecuted, then all of the other ones, people engaged with that case, with the needs of that case, they'll think that they won't be allowed to do this, or they won't be allowed to do that, or and what you've got is you've actually got a lower court, a magistrate's court, making orders, which is actually bossing around a case or a legal case campaign to Parliament, which is in a much higher jurisdiction authority. So they actually become victims because their campaign is being affected, steered by the magistrate's court. And the magistrate's court can't intervene in matters from Parliament. It's almost like the police taking down election material is the courts prosecuting people for parliamentary campaigns, saying you can't do this, you can't do that. The magistrate's courts can't say you can't take these, Stop ULEZ banners here on the street or that street, or you're a criminal because you went here or there with them. These privileged items and materials, just like the election materials.